Good afternoon. Thank you for your kind introduction, Professor Son. First of all, I'd like to extend my appreciation to the organizers of this conference for inviting me. It's a great honor and pleasure for me to speak before distinguished scholars and practitioners in Korea and from China. Today, I'd like to talk about legal issues concerning front-encumbered SEPs, focusing on the treatment of the issues by Japanese courts. The specific topics I'm going to discuss are shown in this slide. To some extent, what I'm going to explain is overlapping with the presentation by Professor John and also Mr. Ikeda in this morning. The court decisions I'm going to touch on are the decisions in these two cases in Japan. The first case is Apple versus Samsung. Mr. Ikeda already touched on this case in the morning. The dispute is concerning the enforcement of Samsung's SEPs related to the UMTS standard. Samsung filed petitions for preliminary injunctions against Apple, an implementer of the standard. On the other hand, Apple sued against Samsung, asking for a declaratory judgment to confirm that Samsung was not entitled to seek damages. And at first instance, the Tokyo District Court issued decisions in 2013, and after appeal by Samsung, the IP High Court gave decisions in 2014. With regard to the first issue of the legal nature of front declarations and their relation to licensing or licensing contract, the IP High Court said, firstly, as to the applicable law, it should be French law based on the interpretation of the IP policy of the standard setting organization, ETSI in this case. And then the court stated that the front declaration could not be considered as an offer for a contract, and no license agreement was formed as a result of the declaration. I think the denial of the formation of a licensing contract by the IP High Court is reasonable from the viewpoint of Japanese and probably French law. In comparison, as you may know, US courts have recognized the legal effect of front declarations to impose a contractual obligation on the patentee to treat standard implementers as third-party beneficiaries. Next, as for claims for an injunction and damages, the Tokyo District Court at first instance dismissed Samsung's petitions for preliminary injunctions and issued a declaratory judgment denying Samsung's right to seek any damages. The denial of remedies was based on the doctrine of abuse of right. After an appeal by Samsung, the Grand Bench of the IP High Court also refused to grant preliminary injunctions and denied the right of Samsung to seek damages exceeding the amount equivalent to the royalty under front conditions. So on this point, the IP High Court, the IP High Court's decision was different from that of the Tokyo District Court in admitting damages up to the level of the front royalties. So in other words, the IP High Court awarded damages equivalent to front royalties, while the Tokyo District Court had refused, denied any damages the ground of the refusal of injunction by the IP High Court was also the doctrine of abuse of right. In essence, the IP High Court said that the patentee should not be allowed to seek an injunction if the defendant or the standard implementer is willing to get a license under the front terms. As for damages, according to the IP High Court, the default rule is to award damages equivalent to front royalties. However, if the defendant or the standard implementer is not a willing licensee, then the patentee can get damages exceeding the front royalties. And on the other hand, if the patentee's claim is found to be extremely unfair, the patentee would not be awarded even damages equivalent to front royalties. Such a treatment of front encumbered SEPs as what the IP High Court did is now prevalent in major countries. However, legal grounds for the denial of injunctive relief and also the damages more than a certain extent are different among countries. This chart shows examples of the legal basis taken by some countries. I don't have time to delve into the details of the differences, but as you know, in Europe, especially in Germany, it is common to rely on the defense of anti-competitive practice to deny or limit the enforcement of SEPs. I'll touch on the competition law aspect later. Then what can we say about the Japanese approach, namely restricting the enforcement of SEPs through the doctrine of abuse of right? I think in Japan, this is almost the only practically possible way to restrict patent enforcement against infringements under our current law. Not only in the context of SEPs, but also in other contexts, such as the enforcement of patents by PAEs. However, the approach using the doctrine of abuse of right has a disadvantage in a sense that the standard is very ambiguous and unpredictable. But as to that problem, I think the IP High Court tried to mitigate such a problem by presenting a general and clear standard. Let me elaborate a little bit on this point. As I said, both of the Tokyo District Court and the IP High Court adopted the doctrine of abuse of right to restrict claims of the patentee. But concrete reasons to find an abuse of right were very different between these two courts. Namely, the Tokyo District Court pointed to detailed facts concerning the negotiation between the two parties, Samsung and Apple, as reasons for the finding of an abuse of right. In that way, the application of the doctrine of abuse of right was very case-specific in the case of the decision by the Tokyo District Court. Such an approach lacked predictability and was problematic from the viewpoint of legal stability, I think. On the other hand, the IP High Court presented a general framework for applying the doctrine, which was much clearer and more desirable from the viewpoint of predictability and legal stability. I skipped explaining this slide, but I'd like to point out that the IP High Court did not present any clear criteria for the judgment of the willingness on the side of standard implementer. In this case, Apple. So as to the criteria to judge the willing licensee or not, was not clearly presented by the IP High Court. That was one of the serious problems about the decision by the IP High Court, I think.